Aloha. And it's not Friday yet. Okay, it's Tuesday. Okay, welcome everyone for our 2026 session for the Committee on Transportation. And testifiers, for your information, we ask you to stand on your written testimony or you limit your oral testimony to 2 minutes. But we'd love to hear from you as well, and we may call you back again. And the live and archival video of this hearing can be found on the Senate's YouTube channel, I guess, after we depart. And you can review yourselves again as well. Decision-making will follow after the hearing from all the testifiers, time permitting. Okay, we'll proceed then with, I need my agenda. Yeah, I got it. Yeah, SB 2008. Oh, here we go. Can I borrow yours? Okay, all right. Okay, and as you note, when you see agendas, just for your information, you know, if it says amended, that means that there was the first one posted and then we added or changed, and that's why it says amended. All right, just so you understand. And you may have had a bill on it and we took it out, but then we can deal with this later. However, let's proceed with SB 2008, and this is relating to statewide traffic code. It establishes 55 miles per hour as the maximum speed limit on all parts of the DKI highway. And let's speak and hear Sherry Bird, Hawaii Police Department. Okay, she's not present, not on Zoom. Interesting. They oppose this. Okay, interesting. Megan Blazak, in support. Okay, Larry Verey, an individual in support, and of course, our director. It's
Chair, members, that's it with Hawaii DOT, stand in support.
This is very interesting. I have to share with you. When I decided, I put the 60 mile per hour. I initiated this when we first opened the new DKI highway, and it was well received. And then, of course, we did have many accidents, and so I was not happy. However, let me share with you, I did this for a purpose. I wanted to test our community and our travelers, just to see. I mean, it's not like I may even defer my own bill, but just to test it, just to let people know how bad things are on our highways. Not only DKI highway on Hawaii County or Saddle Road, as we've known to call DKI highway, but Saddle Road, as we all grew up and knew Saddle Road was there. However, many other highways in our state, and we're not happy. And just to add that, even though that there's opportunities that we can do, you know, statutorily, we can add, we can take away. But when I first announced it, Tribune Herald did it, a good article, guess what? The tons of oppositions came out in social media to my bill. And I'm surprised that we have only this few in one opposition. So I wonder if people realize that, you know, changing from a 60 mile an hour to 50 was problematic to many drivers, even my husband. So no, deal with that kind of stuff. But I'm on that highway a lot. However, we'll see what happens with my bill. But just to give notice that there's concerns that we have, people should realize, you know, don't drink when you drive, stop speeding, and stop road raging, and just be good citizens and worry that your child will probably be one that has gotten so bad that you may lose a person. So just remember, take care. All right, let's proceed then with, reminder, anyone else wishes to speak on SB 2008 on Zoom or present? Okay. Hearing none, seeing none, let's move on to SB 2009, and this is relating to motor vehicles, requires new number plates and tags or emblems for used motor vehicles transferred between private individuals. Director.
Thank you, Chair. DOT stands in its late testimony in support.
Okay, thank you, Director. Megan Blazek. Okay, in support. Larry Vire in support as well. Anyone else wishes to speak to SB 2009? Is that correct? Yeah. 2 times. Oh, okay, here. Okay, Mayor Alameda, County of Hawaii, Mayor's Office, in opposition. Interesting. Department of Customer Services, City and County of Honolulu, in opposition as well. Megan Blazek, in opposition this time. Sorry about that. Anyone else here wishes to speak on SB 2009? Okay, let's move on then. Let's proceed with SB 2026, and this is relating to traffic safety. It requires drivers of vehicles approaching stationary motor vehicles stopped on the shoulder or roadside due to a traffic collision or vehicle maintenance or mechanical problem to slow down and make a lane change if necessary. Attorney General's Office. And happy to have you folks at our hearings. We're very pleased.
Thank you.
We need all the help we can, and we need.
Good afternoon, Chair Inouye and members of the committee. The Department of the Attorney General is in support of the expansion of the law that requires drivers to slow down when approaching a stationary vehicle. To ensure that the law is enforceable, the department has some recommendations. First, the department recommends deleting the requirement that the stationary vehicle is stopped on the shoulder or roadside. Not every stationary vehicle may be on the side of the road. They may be stopped in the roadway or in a traffic lane, especially when the vehicle is disabled. The second recommendation is that we delete the condition that the stationary vehicle be stopped due to a collision or a mechanical problem. In enforcing the law, it may be difficult to prove that an approaching driver could reasonably determine that the stationary vehicle was stopped specifically because of a collision or a mechanical problem. If you delete the provision, then drivers will have the duty to slow down when they approach any stationary vehicle that has its emergency lights flashing. The third concern is that the current law only requires a driver to slow down when it's approaching a emergency road situation. So under the current law, an emergency vehicle can be stopped for an emergency, for a routine traffic violation, and to render assistance. So therefore, under the current law, there's no requirement for a driver to slow down when approaching an emergency vehicle if the emergency vehicle is stopped for a routine traffic violation or for rendering assistance. We think that if that condition is deleted, then drivers will be required to slow down when approaching any emergency vehicle, stationary vehicle that has emergency lights flashing. The fourth recommendation is that the definition of stationary vehicle be deleted. HRS 286-2 already defines vehicle. Stationary simply means stopped or not moving. So the department feels that there's no further definition needed. And finally, I want to apologize to the committee and correct my written testimony. In my written testimony, we asked that additional language be added that the stationary vehicle be unable to proceed when stopped. That is, we want to eliminate that addition. Stationary vehicles may be stopped for a variety of reasons. In a minor fender bender, the car might be stopped but able to proceed later on. Therefore, we'd like that requested addition deleted. So thank you
Be
very much.
deleted. You want it deleted?
Yeah, we added it by mistake, and
Okay.
upon closer review, realized that's probably not the right thing.
And members, feel free to ask questions when our testimony is being presented anytime. Okay, I think it's much easier while they're still here. Okay,
Okay,
thank you so much.
thank you.
Okay, thank you. Duty. And maybe good you can, if you want to add to the Attorney General's.
We stand support and we like your
Okay.
comments, so it's really good.
Okay, thank you. Thank you, Ed. Blake Oshiro?
Blake Ashore on behalf of AAA, we stand in support on our.
Okay, and also for you folks as well, if you feel like, you're interested in this measure, also because the Attorney General is here as well. So you can also ask a question to the chair, and we can ask the Attorney General to come to explain if you have any comments.
So we like
Okay.
that proposal amendment.
All right, thank you so much. OMPA, and that's the Oahu Metropolitan Planning Organization, and they're in support as well. Anyone else wishes to speak to SB 2026? Okay, please come forward. Good to see you again. Happy New Year,
Happy New Year.
our famous bicyclist.
Chad
How many pounds have you lost so far?
Not enough since I
Okay.
don't commute. But I remember when the move over law was passed in 2012 with Major Kurt Kendro of HPD and Hawaii Bicycling League pushing it. And the short blurb that describes this says, requires drivers to slow down and,
Sorry, gotta introduce yourself
Oh.
again, sorry.
oh, sorry, Chad Taniguchi.
Okay, thanks,
Yeah.
okay.
The short blurb says, requires drivers, etc., to slow down and make a lane change if necessary. And I'm not sure what the language actually says, but shouldn't it be that they slow down and make a lane change, not if necessary, but that when they see that, they do that?
You're
You know-
asking me the question, I'm gonna call Ed or our Attorney General here.
Yeah, okay, thank you.
But you're asking me, so I would prefer hearing from them as well.
I think the attorney would be awesome.
Okay, all right, Attorney General, okay.
So we looked at that.
No, you know what, we have folks on Zoom as well, so things are being recorded and for clarity as well.
So we looked at that provision, and I think the issue is that it may not always be possible for a vehicle to make a lane change. And so that's why there's sort of that qualifying condition that only if necessary and safe. So we agree with how the bill is currently worded, because it just might not be possible.
Okay, all right, Chad, are you gonna be confused or questions? Sit down, yeah, Chad, you too. Let's hear the discussions.
Well, I remember, Chad Taniguchi, in 2012, the law was passed because 2 police officers were killed that year and, helping with a roadside stop. So the move over law, in my mind, was mandatory, that you had to move over at least one lane. So if you're gonna say, if necessary is in the mind of the driver, then they may feel like, hey, it's not necessary. So wouldn't it be better to find some other language that says when there are 2 lanes, or when you can, let's see, I wouldn't expect them to go into the opposing lane of traffic because that's dangerous too. So you know what I'm saying? Make it mandatory that they move over when it's possible to move over.
Right, and I think, the issue is, it just might not be possible. So even in a 2-lane road, if you have like a multi-car pileup in one lane, and for some reason the police officer's on the shoulder, there's no lane to change over to. So I think I know, I understand what you're saying, but I think we just can't accommodate every single situation. It
But
just
you know
might-
what, on Big Island, we got many only 2-lane roads. So
Yeah.
that's, yeah, so
So it
we
might just not be
experienced that.
possible.
And what happens is they close the road entirely. In most cases.
Right.
So, may I speak?
Sure.
Yeah, but if you're talking about enforcement, if the driver knows that they must move over, but then in their mind, of course, using their common sense, they're gonna see there's no place to move over, then they're gonna slow down. But what about the guys where there is room and they don't? That's the guys you want to have the requirement. So I say though, it's not perfect, but
Yeah.
there's way to make language so that in their mind, they must move over.
Yeah. and I-
Well, when you do statutorily changes or additions to some complications may also refer back to insurances as well. You know, what the law says and, you know, how it applies. So I'm not sure. Anyone has some questions? No? Okay.
You know, I think, and that's why we were requesting some of the language be cleaned up as far as enforcement is concerned. So
Sure.
we want to make sure that as long as the vehicle any vehicle stopped on the side of the road and its emergency lights are flashing, you have to slow down. And then if possible, you know, change over, you know, to another lane. But we're trying to simplify the enforcement and make it easier for that violations to be established and proved.
And did we cover what happens aside from a car, if there's something happening on the shoulder and there's an accident in the lanes, the moving lanes? So if there's an accident there, the vehicle must, if the vehicle that was part of the accident remains there, must be there, right?
Right, and so that's why we're recommending that the requirement that the stopped vehicle be on the shoulder of the roadside, that language be eliminated, because there are situations where the vehicle might be stopped in the roadway. And we want the driver to have a clear duty to slow down and if necessary, change lanes. So in that case, you know, if it's a single lane, hopefully the officers on the scene, they have to direct the drivers around whatever the obstruction is.
All right,
Senator,
Okay,
there's an organization that was started because a tow truck driver was killed, yeah, in trying to tow somebody off. So I just want to say, to me, if you can find a way to make it where it's possible, they have to move over, I think those people who work on the roads would be benefited.
you know, who goes on the shoulder in this incident?
The tow truck was towing a car that was disabled,
Yeah,
and the tow truck operator was on the side of the tow truck.
okay, so the tow truck hasn't moved yet?
No,
It's
hasn't
still
moved. Yeah.
stationary, and then they loaded the car onto the tow truck.
And in that process, a car that did not move over killed the tow truck driver.
So the passing car
Yeah.
then.
Yeah,
That's why we have to be careful when we're driving. Keep your eyes on the road and see what's happening. So, but thanks
okay,
for
thank
the
you.
discussion. Okay, thank you.
Thank you, and for the record, Michael Moriyama, becoming
Thank you.
Deputy Attorney General.
Thanks.
Thank you.
Anyone else wishes to speak to SB 2026? Okay, hearing none and seeing none, let's proceed to SB 2053. This is relating to transportation. This authorizes supporting documents used to transfer ownership of a motor vehicle to an insurer after payment of damages from the result of a total loss insurance settlement to be signed electronically, requires insurance companies to indemnify and hold harmless the Director of Finance for any claims resulting from the issuance of motor vehicle titles utilizing documents signed electronically without a notary. And this is DOT Stern.
Thank you, Chair. We stand in support.
Okay, thank you so much. AG, no comment on this one, yeah? Honolulu, City County Customer Services in support. Mike Onofrida testifying for Hawai'i Insurers Council. Come on up.
Mike Onofrida, we stand on our testimony in support and are available for any questions.
Thank you so much. Thanks for being here. Mark Binder on Zoom and testifying for Copart. Aloha.
Aloha and good afternoon, Chair Inoue and Vice Chair Elefante and the members of the committee. Just thank you for this time. I really appreciate it for Copart. My name is Mark Bender. It's Binder, and I'm testifying on behalf of Copart for support of SB 2053 with technical amendments that there was a few errors in the language which were caught, and we're asking that those be amended as well. Copart is a vehicle auction service company across the entire United States, and we have a facility in Kapolei, and we service the entire state. Our business model involves working closely with insurance companies. What we do is we liquidate vehicles that have been declared a total loss following a claim settlement. And 2053 modernizes this process by allowing electronic signatures for transfer from the vehicle owner to the insurance company without a notary. So you can see this is a very narrow transaction type, but with significantly reduced delays for customers. Because if you think about it, under the current system, owners must locate a notary, mail title documents, which could take several days or longer. And they're doing this all without a vehicle because their vehicle's a total loss. So the bill allows many of these transfers to complete much more quickly, often in one phone call. And it's helping people with families replace vehicles and return life to be normal a lot sooner. So this is very similar to other laws across the country, and it's supported by federal and national transportation authorities. I just lastly respectfully ask for your support of 2053 with the technical amendments, which is described in our written testimony, which you should have. So thank you for the opportunity, and I'm definitely available to answer any questions you may have.
Thank you, Mark.
You're
Another
welcome.
Mark, Setnan, testifying for the American Property Casualty Insurance Association, also in support. Is there anyone else wishes to speak to SB 2053? Otherwise, we will say aloha to that one, and we'll proceed with SB 2172, and this is relating to vehicles. It allows an all-terrain vehicle to drive in the evening and night if they are equipped with headlights, taillights, turn signals, and brake lights, and while displaying a slow-moving vehicle emblem. It also allows the drivers from all-terrain vehicles to wear a safety helmet with a securely fastened chin strap rather than require, and includes the definition of utility terrain vehicle, a motor vehicle that accommodates one driver and one passenger sitting side by side and up to 6 people in seat belts, and it includes all-terrain vehicles in the definition of motor vehicle under the state's motor vehicle insurance laws. DOT.
Hello, Chair. Ed Sniffen with the Department of Transportation. We sent in our comments to this bill with some concerns for the use of this type of vehicle on the facilities. That all being said, though, we want to make sure we can support our ag producers. So we were looking at this bill and we saw we could support this if these vehicles were kept in areas of low speed, so 35 miles per hour or less, and the helmet requirement goes to a shall versus a may. Thank you.
Okay, thank you very much. Megan Megan Oka, Attorney General's Office, thank you for being here as well. And thank you for being here in person. It's better being on Zoom.
Good afternoon, Deputy Attorney General Megan Oka. We submitted our written testimony, available for comments if there's any.
Okay, thank you very much. This sounds like more of an ag bill in its entirety, yeah. Okay, all right. City and County of Honolulu, Customer Services, in opposition. Hawaii Farm Bureau, in support, and an individual, Tia Hiroa Fukumitsu, in support. Is anyone here wishing to speak to SB 2172?
Chair Noe, Matthew Jumar on behalf of DCCA Insurance Division. I believe we submitted written testimony, but we'll stand on our written comments.
Okay, come on up. I want to know what the comments are.
I know we didn't get anything.
Our testimony simply stated that as written, the bill would require ATVs to have and at all times be insured under a standard motor vehicle policy, which would be subject of our cars that we drive. ATVs would be required to have that level of insurance under the current provision of the law. So that's simply what we were noting.
Okay, and interesting because ATVs, I think in the industry as well, in ag, rarely are provided any type of insurance or coverage. They're not even covered to be on the road, right?
Well, ATVs, there are certain products that apply to ATVs, such as, depending upon the actual business that's being conducted, whether, for example, say the rancher or the ranch owns a general liability policy that would cover everything, the scope of all of their activities, that might include ATV, actions. I think on the flip side, you have things like your recreational use ATVs that are covered by recreational policies as well. So this would sort of create a new scheme, I guess, for ATV insurance structures.
In my mind, ATV would be like those small scooters or big scooters or whatever people use to do transportation or recreation, more recreation. But interesting that this measure says to include a utility terrain vehicle. So in your mind, what is the utility terrain vehicle?
Well, I think to take a step back, Senator,
Truck.
I think the bill actually only addresses ATVs. So it's only amending sections to include ATVs. I believe the UTV portion of the law is untouched. But my understanding of what a UTV is compared to an ATV, this may be incorrect. So Ed, I apologize if this is a mischaracterization, but UTVs I think of as like golf carts. ATVs are sort of like the ones HPD drives around on, like at Waikiki.
Well, you look at golf courses, the golf vehicles. I'm a golfer, so I know what it is. But this says, include the utility terrain vehicle, a motor vehicle that accommodates one driver, one passenger, sitting side by side, but up to 6 people in seat belts. But I've never seen a golf cart that can do both, except for those, I guess, probably used in transportation. And I'm not sure if Kilohana on Kauai that hosts, that has a lot of luncheon guests, and they do tours on their farm. They may have a vehicle that's probably up to 6 people that I've seen. But interesting. But anything to do with agriculture activity, this is referral, it's interesting because not too many agriculture industry works at night, except for pineapple industry, the flower industry don't work at night. But if it's a concern for a community, it sure would be nice to know, who benefits what particular area. Because sometimes there are areas that shouldn't be on the road at night, particularly, the industry that supports ag, but I'm not sure if I really understand and we're farmers, so We just want to make sure, though, that those in the industry, in agriculture, that do probably be at night and must transport their employees for one reason or another, or the size of the farms, if it could be thousands of acres, would benefit as well. Members, any questions you may have? Yes, Senator Deport.
And this might be a question for DOT, but with regards to the term utility terrain vehicle, are you anywhere under the impression that this includes golf carts?
I think golf carts is already covered under low-speed community vehicles, and it's already allowed. I think there was something in the law that we had to adjust to allow electric golf carts in the past, and I'll check on that. But when I look at UTVs, I'm considering things like Polarises and those types of vehicles.
Yeah.
That's what I was
Yeah.
under the impression of.
Yeah, so when I read this bill, and maybe correct me if I'm wrong, when I read it, I see that it's written for rural areas and focused on farm lots. So I'm reading it as going from field to field or location to location
Sure.
for those purposes.
And I can see that because, take as an example, my island, the district of Waimea, you have lots of farms there. And the danger that I see in the Hamakua coastal, where you have a highway, and that's pretty concerning, particularly when you don't have good lightings on the highways.
Yeah, and this is why I was saying that we could be supportive if this is limited to areas of low speed. If it's on a highway, we cannot be supportive
Oh,
like
okay,
this.
I got you. Okay, any further questions? Thank you so much.
Thank you.
Okay,
you.
anyone else wishes to speak to SB 2172? Okay, we'll say aloha to that one, and then we'll proceed with SB 2253. This is relating to highway safety, and this amends the offense of negligent injury in the first degree to include injuries negligently inflicted by intoxicated drivers. And DOT.
Chair, DOT is in strong support.
Thank you. Maui Prosecutor's Office, in support. Okay. My island, testifying, County of Hawai'i, Office of the Prosecuting Attorney, in support. And Ompo, testifying from Oahu, Ompo, in support. Daniel, Hugo, Prosecuting Attorney. Okay, good to see you again. Thank you.
Good afternoon, Chair Inouye, Vice Chair Elefante, Senator DeCourt, Senator Lee. Daniel Hugo for the Honolulu Prosecutor's Office, and we are in support of this bill. We welcome the support from the Maui Prosecutor's Office, but we would respectfully disagree with the offered amendment. The language that we chose was deliberately to ensure that this offense could continue to be prosecuted as a lesser included offense of negligent homicide. And so it's made to reconcile with the negligent homicide statute rather than importing OVUII and the DUI laws. I'm available for questions from the committee, and we would appreciate support on this bill. Thank you.
Okay, and I believe County of Hawaii also had some, you had a chance to look at the County of Hawaii's amendments.
I have their testimony with me. If I could just briefly review.
Yeah, and was it differ then from the Maui County? Was Kauai, was that the one that you made? It's attached. Okay. 2253. Oh, no, this is 2355. 2253. Here, I have it here. Yeah.
His amendments is
Okay.
back here. This is it.
Okay.
So I think the amendments were offered from County of Maui. In general, the County of Hawaii's comments we are in agreement with.
Oh, the Maui's amendments. This is the one you said you don't support.
Yes.
Okay, all right. Thank you. Okay, just for clarification, thank you so much. Okay, in support, citizen of Hawai'i. Okay, it can be all of you. All right, okay, citizen of Hawai'i, your turn. Okay. All right, anyone wishes to speak to SB 2253? We're going to say aloha to that one. We'll proceed then with SB 2355 relating to vehicle safety. And this requires the Director of Transportation to adopt rules allowing for mobile vehicle safety inspections, DOT.
Thank you, Chair. The DOT has submitted comments on this. Let me just, if we ask. We just submitted comments on this. Just with discussing the potential impacts for cost and consistency as we push a program like this. So we submitted comments. There's no, we're not against the bill like this. We want to make sure that we look forward to seeing how we can better service our communities. We just haven't put the work into finding out more information on how this would work for Hawaii.
Okay, thank you. Any questions of the director? Okay, hearing none. Nicholas Wong, an individual. Yes, aloha. Thank you for being here.
Chair Inoue, Senator, Vice Chair Elefante, Senator Decor, Senator Lee. My name is Nicholas Wong, just in support of this bill. Really, it's just, in my mind, a common sense bill. I've had issues, I guess, trying to get our safety inspection with inspectors not being there or canceling appointments, and it's just a little tough. And I think we're in a little age where we're finding that a lot of these inspections are able to be, are required to be done with an iPad that they take pictures of and everything's recorded. And we don't really see the issue of being able to do it or tie it to an actual vehicle inspection site. I did see some comments that came through from the Department of Transportation regarding kind of quality control. And I really think that's really got taken care of by the iPad situation. Everything is really now taking pictures, recorded. And the equipment technology, again, we're in a little age where we have cell phones that can mobily, transport all of our data, all of the inspection reports, all of that. And I think kind of the last one is that inspector safety. In my mind, it would be just, areas, especially even the Capitol, where there's a lot of cars parked downstairs where we can get our inspections done while we're at work. And again, that's kind of my thought on it. And again, I did see at the bottom where it was, to do a pilot program. I mean, we're happy. In my mind, I'm happy to have any conversation to kind of keep this bill going. So I think a pilot program would be even fantastic. But thank you, really appreciate your time.
Are you in the business?
No, absolutely not.
Okay, well, reason I ask is, this sounds like, with technology now, anything's possible. AI is waiting to come in anywhere. DOT, part of the inspection and, with this process that's recommended by this measure allows the only thing, we all drive, but how would one inspect the braking mechanism if we're doing it by phone or electronically? Because to me, I think the inspection part, braking to me is one of the important inspections that should be done on a vehicle. So I'm just kind of curious if it would be an impact or it shouldn't.
Yeah, from the research that I've done, kind of looking through the HRSs and, the requirements seen there. And again, to me, it seemed like this whole vehicle safety inspection really began in the process of, before when we, they would actually drive your car, lift your car, take a better look at it. And what it's evolved to now is just turn your blinkers on, flashing lights. And, rather than try to solve really that big problem of, where does these vehicle safety inspections go? I really believe that,
the comments from DOT, it's part of, the rulemaking as well. And I think the director did say that they're willing to look at all these, 6 points, I think that was recommended in this testimony.
Yes.
You had a chance to?
Yes, I did.
To see it.
And I think all of those are very valid comments.
Okay.
And yeah, again, really, it's just kind of keeping that conversation going. And
vehicle inspections has always been an issue with this we talked about having inspections every 2 years. That never passed for some reason, but I think maybe we should even consider going back to it again. I don't know, it's,
It's not.
okay. Yeah, that's why the bill never passes. But see, that's a good discussion because I don't think I introduced one like that.
Yeah.
But, it's good for, to hear things. Okay.
Yeah, so we're interested in looking to see how we can improve the services to the public. We got to make sure we talk to our service providers to see how they would provide those services and how we make sure that we keep them consistent. Several things we want to make sure that vehicles are in good working order when we review them, so that when they get on the system, they don't, A, cause any delays to everybody else on the system when they break down, or two, cause crashes or fatalities as they're out there. Those are the two big things. But now we tied our inspections into our road user charge program.
Yeah.
Very difficult for us to go to a 2-year time frame now because everybody's paying off of that road user charge or that inspection time. So it's difficult to decouple those types of things. But always easy to look at how we can improve the services to ensure that it's a minimal impact to everybody.
Yeah, good, thank you.
Thank you.
Okay,
I have a question for
questions?
DOT.
Yes, Senator Elafante.
Thank you, Mr. Wong, for your testimony. If DOT, as suggested in your testimony, would look into a pilot, would that something DOT would procure out and go out for an RFP for
Yeah.
mobile inspectors?
We would just do it probably off of the contract that we already have with our mobile inspection program. But I gotta see how we set that contract up.
Okay, thank you, Director.
Thank you.
Thank you, Chair.
That would be kind of interesting because if one does it on your own car, I can see quite a bit of consequences, whether it's good or not, but how it relates back to the person
Yeah. So
or,
from my perspective, it
Yeah.
would be certified inspectors that would be able to do it,
Oh,
right?
okay.
Right now, that certification is given to a location, a business in a location. It could be given to inspectors per se, and it could potentially increase the number that we could have to service the community. But like I said, I gotta check on it to make sure.
I think we really need to kind of study this as well because as we all know, sometimes, and I think was already mentioned, that it takes a while to get your inspection scheduled as well. And so,
Yeah, for me, I just schedule them when I do my service. So every 6 months when I take them in, I just have them do the inspections.
I think I do that too as well. Okay, moving on.
Thank you.
Thanks so much. Thanks, Nicholas. Kenneth Hsu? Okay. Your perspective?
Hello, good afternoon, Chair, Vice Chair, and members of the committee. So my name is Kenneth Hsu. I came to just voice my support for this bill. I think that it's something that could be, revolutionary in a sense, because safety checks have always been like this ever since I started driving, ever since my dad would take me with him to get his safety checks done. And throughout the decades, same issues always arise. And for me now as a driver for the past decade is same things. Drive down, hopefully there's someone there to check your car. If there's not, I'll come back tomorrow, and then it's delayed, and then trying to get an appointment, you can't get an appointment. So I think this would add a lot of convenience as maybe not the requirement, but as an option to have. Because for me, as you guys touched on, currently there's so many new technologies coming out for, you can have someone coming to your house to wash your car, deliver your groceries and things like that. So I think this would be a very good option for people that would like it. And yeah, I think I'm excited to see this go through and see how it does pan out because I'm sure like any other drivers, I'm not an expert of how to know if my car is safe, and I would like to kind of see some learning from the inspectors coming over, maybe chatting with them, because sometimes when I go get inspectors now, I'm just in and out. They just look at a few things and then I go home, but it'll be interesting to see.
So you support the inspection program that we have?
Yeah, and it'll be interesting to just learn more and kind of see this grow, so,
Good, thank you for your input.
Yep.
Thank you.
Okay, thank you.
Director, I have a question. You know those heavy trucks that transport heavy stuff, cargo, do they go through inspection?
They do. They have
You
their
know
own
why?
inspection program.
I don't know. Because my eyes are always open on the road, and I followed some of these big trucks on my island and in Hilo. I don't see the safety sticker
Yeah,
on the
so-
trucks.
So we took over
So I thought,
enforcement.
oh, maybe they're exempt.
No, they're not exempt. So we've taken over enforcement. It used to be broken up before. The safety check portion was with the DOT, and PUC used to take care of the registration and all that kind of stuff. We pulled it all into DOT now to make sure we can enforce everything together. So if you do see any areas where there's trucks without the formal requirements, let us know so we can get out there.
There's a
and take care of
lot,
that.
you know, those that transport the the medicine containers, we got heavy stuff, water carriers, I mean, those that sell the water and the tankers.
Mm-hmm.
Yeah, I followed them, and maybe you keep your eye on your road in your
Yeah.
district too.
I know West Side had
And the
plenty too.
construction, and I'll tell you,
Yeah.
construction companies as well. So I don't know if the stickers are in another part of the vehicle, but don't you always have the sticker in the backside?
Yeah, backside and the side of the truck, we have the requirements too.
Okay, so they are not they're not exempt?
No, not exempt.
Okay.
Yeah.
Yeah, Senator Court, you have a?
No, I was gonna ask that also, if they have their sticker in a different location that maybe we're not identifying, but I think you answered that
Yeah.
already, so, yeah.
Yes, and just so I'm clear, when I read the bill, I saw this was for motor carrier vehicles. Those are the commercial vehicles. But what we're talking about right now is you want to see the safety check program for passenger vehicles, right? This mobile safety check program for passenger vehicles.
Well, this one here is motor carriers.
Yeah, so the way the bill is written is for the commercial
The
vehicles.
commercial
And I don't think that's the intent. It's not just based
Yeah.
on what I'm hearing from testimony here.
Yeah, you guys understood that too?
That wasn't the intent.
Okay, so we're looking at passenger vehicles. Okay,
Yeah,
so maybe that's an amendment that we gotta consider in our next,
yeah, okay,
okay.
all right.
Thank you for clarifying that. I
Good
wasn't under
catch.
that impression.
Rex, did I call, Chris Ito in support? Rex Katahara in support. Anyone else wishes to speak on SB 2355? We'll move on to SB 2392 relating to traffic safety. And this specifies that operating a vehicle under the influence of an intoxicant while a highly intoxicated driver is a Class C felony, and outlines additional requirements for probation. Director.
Thank you. DOT supports the intent. And the only reason we cannot say we support is because I know that the AG had some concerns that they're trying to work through right now. So we'll work with them.
Okay, let's see, Attorney General, were you here on this? I don't see, I don't see you on. Let's proceed then with Judiciary, followed by Public Defender.
Good afternoon.
Good afternoon.
Good afternoon, Chair, Vice Chair, Mr. Court, Senator Court. The judiciary stands on our written testimony. We're providing comments. We make have no position on the bill itself. We just wanted to identify the impacts that might happen operationally for us, both for our trial divisions as well as probation services. And I'm available for any comments.
Okay, any questions? Hearing none. Thank you for being here. Okay. Public Defender. Aloha.
Good afternoon, Chair, Vice Chair, and Senator. My name is Haley Chang. I am the First Deputy of the Office of the Public Defender for the state of Hawaii. We have submitted testimony in opposition to this bill, and just wanted to highlight a few important takeaways from our written submission. First and foremost, the current statutory scheme already penalizes highly intoxicated drivers beyond a normal DUI offender. And that language is already in the existing measure. Secondly, as we've noted, and in a report that we've cited by the AGs, which is old, but we believe an updated one would be consistent, that most DUI offenders are first-time offenders. There are a handful of those that come back as repeat offenders, but most individuals learn from the first time. These are not the normal criminal that is out there in our community. Oftentimes it is somebody who is inexperienced with drinking, went a little too far, does not know their limits, but does learn. So we highlight that because making a criminal felony offense for a first-time offender for this, we believe, is overly harsh. Third, in echoing what the judiciary submitted about the burden on the system, creating a new felony is a significant departure from what is now currently a petty misdemeanor offense. This requires not just additional resources for the attorneys, but for the courts. These cases are highly litigious. If you take a stroll down the district court, you can see how many of these DUI cases are actually do go to trials, which are primarily bench trials in front of a judge. But when we're basing something on what is just a metric, 0.15, any DUI expert or defense attorney will tell you there's a lot of problems with the testing and the way that those things are done, so it's highly litigated. And we're also asking of the committee to consider all of the unintended consequences of this measure. I'll be available for questions, and thank you for the
Thank you so
opportunity
much.
to comment.
Thank you. Thank you. Any questions? Okay. Office of Prosecuting Attorney, County of Hawaii. Keldon, aloha. Keldon, you're on.
Hello, Chair, can you hear me?
We sure can. How's the weather in my town?
Today's a good day.
Okay, all right, that's good. I heard it's gonna rain Super Bowl day and we're having a party, so I don't know about that. Okay, good seeing you.
Good to see you too. Aloha, Chair Inouye, Vice Chair Elefante, Senator DeCourt, Senator Lee, Hawaii County Prosecuting Attorney Keldon Walgen. We stand in strong support of this bill. Highly intoxicated drivers who have a BAC greater than 0.15, which is nearly double the legal limit, they pose a significant threat on our roadways. According to the National Highway Traffic Safety Administration, in 2021, 67% of alcohol-impaired driving fatalities involved the driver with a BAC of 0.15. Driving at that level demonstrates an extreme disregard for the safety of others, and it puts everyone at risk. In consideration of the statements made by those in opposition to this legislation, I want to bring attention to my written testimony where I made a recommendation to create a graduated penalty structure. As such, a first high intox DUI would be a misdemeanor. A second high intox DUI would be treated as a Class C felony. My proposed SD1, which is attached to my written input, also poses a loophole and addresses an ambiguity related to deferred pleas and DUIs. The proposed SD1 was circulated amongst the membership of the Law Enforcement Coalition and statewide traffic commanders. I feel for my colleagues at the Honolulu Prosecutor's Office and the Oahu community at large after reading comments. Not having a procedure in place with the First Circuit Court to review search warrants electronically is a significant concern, and it puts the public at risk. I hope that the judiciary can prioritize addressing that issue this calendar year, but that shouldn't discourage this committee from passing this legislation. Hawaii Island needs this. Also, I've reviewed the written testimony by the judiciary where they shared data regarding the number of charges against highly intoxicated drivers. That data alone shows exactly why we need to increase the penalty structure. If what we're doing right now isn't working, it hasn't decreased the number of highly intoxicated drivers on the road, clearly the petty misdemeanor offense is not sufficient. I encourage the committee to pass this legislation. There's overwhelming support. There's even support from members of the alcohol industry. This bill promotes traffic and public safety. Mahalo for the opportunity to testify today. We submitted our written input. I'm available for questions.
You heard the, Keldon, did you hear the public defender's comments?
Yes, I did. I know they're
comments?
concerned about the number of cases and how
The
it.
first time, yeah, I guess those that are affected for the first time. Can we hear your recommendation or?
Yes. So my SD1 that I attached, instead of leaving it as a petty, I'm recommending that it be graduated to a misdemeanor instead of a petty misdemeanor.
That's in your recommendation, yeah?
Yes.
Public defender comments.
Yes, it's in my the proposed SD1.
Yeah. You had a chance to see his,
No, I apologize, Senator. I've not had a chance to review Mr. Walton's amendment, and Kelton, I'd be happy to have a conversation with you offline as well. What he is proposing would be much more in line with
Okay.
what we would be maybe not outright supportive of, but less concerned with. Like we said, the stark departure from a petty misdemeanor all the way to a Class C felony is really significant, not just in the penalty structure, but on the impact on the system as a whole. And I do think a misdemeanor offense, while again, is not our ideal resolution, it would address and maybe acknowledge the fact that most DUI offenders are first-time offenders.
okay, all right, thank you so much.
Thank you.
Calvin, any comments? Calvin, you okay?
No, just mahalo again for the opportunity to testify today. I appreciate it.
Thanks for working on this as well. Any questions of County of Hawaii? Okay. All right, aloha to everybody back home. Thanks a lot. Let's see, Sitting County of Honolulu. Yep. Thanks for bearing with us too. I know
Not
we've
at all.
been in this building every day, so we appreciate your comments and your visit with all of us.
I think the forbearance goes both ways.
Yeah.
Good afternoon, Chair, Vice Chair, and members of the committee. Daniel Hugo for the Honolulu Prosecutor's Office. We offered comment on this bill, but I want to clarify, we are in strong support of the intent of this bill. Highly intoxicated drivers are among the most dangerous on the roads. They absolutely deserve felony prosecution. In direct response to the public defender, I don't care if it's their first time that they did it. Oftentimes, it's the last crime that they ever commit. So in terms of the intent of the bill, we support it. But what our testimony points out is some of the effects that will occur on the island of Oahu. And that's only because here, unlike the neighbor islands, the First Circuit, the judiciary has not set up a consistent system for electronic and telephonic warrants. And that arises from a judicial decision over a decade ago to do two things. Number one, struck down the law criminalizing refusal that this legislature had. The judiciary decided to do that. Second, the judiciary also decided that they would subject breath tests to the warrant requirement, which departs from the much more sensible distinction that the United States Supreme Court took when it said that warrants for blood tests, absolutely, but for a breath test, they're going to treat it as a search incidental to arrest. So given that, the consequence on Oahu is that many people are refusing. And because we don't have a system in place, we do have one judge who worked on a blood warrant, and we appreciate that judge for stepping up in the First Circuit, but we do not yet have a reliable system. So the likely effect of this bill only on Oahu will be a higher refusal rate. And so it's unfortunate because many of the times we get evidence that the person was highly intoxicated because they consented to the test, whereas people who just contumaciously refuse can't be prosecuted at all in many instances. So just wanted to make the committee aware of that, but there should be no ambiguity about the fact that we believe that these people do deserve prosecution. Thank you.
Okay, thank you so much. Maui Police Department, Nicholas Angel, in support. Let's see. Seating County of Honolulu. Oh, you already did this.
CSD.
Okay. Maui Brewing Company, Garrett Marrero. And thanks for making time to be on Oahu.
Oh, yes, ma'am.
Okay?
Thank you for the opportunity.
You know, it's great to have people like you in the industry, you know, come to testify as well and just share comments, and we're pleased to have you.
Thank you. Well, it's an important issue, and we care about Hawaii, so it's important.
Sure.
Yeah, first, I'd like to be very clear. We're adamantly against anyone drinking and driving. I know it's obvious, people make the connection. Hey, you make beer, so you're here to oppose this bill, and frankly, it's the opposite. We support the intent of the bill. I am not a lawyer. I make beer. All the class C's and D's and all of this, I don't understand. So far be it for me to impose punishment. However, I do believe that strong enforcement and strong punishment and accountability for anyone that is driving under the influence, especially causing accidents, injuries, and deaths especially. We have 4 restaurants and the production brewery, and oftentimes if someone even comes in from off the street, not one of our locations, we'll pay for an Uber, or we'll get a cab, we'll take them home. Even in some cases now is a much smaller island, we can do that. But my testimony today was really about comments where we support the intent because we believe no one should be drinking and driving. In this age, we have a computer in our pocket that can get us home safely from nearly anywhere on the planet. So that's, I think, a really good factor that we shouldn't be drinking and driving. However, we think the stronger punishments, and maybe there's a tiered system for first time all the way through recidivists and such, but most of the accidents that are causing injuries and certainly deaths occur, according to NHTSA at least, over 67% of the accidents occur above 0.15. So I'm here to support the intent of this bill, and my comments are that it should always be strong penalties for anyone violating the law. That's for you to determine what those penalties are. And however, you'll hear us testify later, we are in opposition to another bill that lowers the threshold to 0.05 because most of the accidents occur at a much higher rate. And I think these first-time offenders, even whether it be low or highly intoxicated, would be, let's just face it, if accountability is a real thing, the harsher the penalty, the more likely someone is able to pay attention and say, hey, maybe I just won't drink and drive. And that should be what it is.
Your time is up,
Thank you, ma'am.
But then you're also here for the next measure
We
that
are.
you're in opposition.
We
So
are, yes.
We'll spend time with that. too.
Of course,
Thank you
yes.
so much
Thank
for
you,
being
ma'am.
here.
Aloha.
Okay, testifying for UMPO in support. Steve Harmschild, Lanikai.
Hi, Chair, Vice Chair, members of the committee.
Thanks
Thanks for
for
the
being here.
opportunity. Appreciate it. Just to kind of echo a lot of Garrett's comments, we're definitely in support of increasing penalties for people that obviously consume and then drive and make our roads unsafe. And that's definitely what we want to see is safer, just logical legislation that goes after the people that are doing this. As he mentioned, we have a lot of repeat offenders in the state, and many of the fatalities and things are coming above 0.15. So a law like this is something that we stand behind and support, and it's something that not only protects our community, but it protects our industry as well. Just keeps everybody safe and gets everybody home safely. So,
Okay,
thank you.
thank you so much. Thanks, Steve. Thomas Kearns, an individual in support, testifying Kauai Island Brewing Company. Brett Larso in support. A person named Lily in opposition. So Lily drives, I hope. Maybe she doesn't drink beer, maybe. Okay. Anyone else wishes to speak to SB 2392? We're moving along.
Chair,
Yes.
could I just ask one
Yes.
follow-up question to the prosecutor's office?
Sure.
Thanks very much.
Yes, Senator Lee.
Thank you. This issue has been obviously around for some time with respect to the issue you raised, which is the inability to compel drivers who are suspected of being way over to actually submit to a breath test.
Right.
One of the other measures we entertained last year, and I know there's a couple floating around this year as well, would sort of flip the paradigm and say, all right, if you're pulled over and asked, will you submit to a breath test because there's probable cause, you're swerving, you're whatever. And if you refuse, then it's an automatic revocation based on your compact sort of the state has with you when it issues you a driver's license on the premise that you're not going to do that. you're not going to drink, and drive, and you're going to submit to a test. Currently, the way it works, you go through an ADLRO process, or due process there, and if there's sufficient evidence or whatever it might be, your license is then revoked. We had heard earlier from HPD and other law enforcement that because that process is so lengthy and so many hoops that both law enforcement and prosecutors and others have to jump through, that for the most part, like, it kind of amounts to nothing by the end of the day. So in other words, there's really no penalty for just refusing up front. Is using that moment at point of refusal to put some sort of penalty or other thing there and flip it such that you lose it and you can go and appeal and get it back. We're still enabling full due process and everything else, but in that moment, until you go through that, we're revoking your license. Does that comply with the Supreme Court precedent that you cited here in Hawaii? And or are there other means in that moment to be able to put in some sort of other penalty simply for refusal?
So the one decision did leave open administrative penalties. So if those administrative penalties, at least the way that I read that case, if those administrative penalties don't amount to an effective criminal penalty, and if they don't in some other way compromise procedural due process, then it should be fine. And at least the scheme that you're proposing, which would be a presumption that the license is revoked, would be helpful, especially in cases where those people continue to drive even though they're on a suspended license, because oftentimes the facetious defense that's raised is that they didn't get the ADLRO notice in the mail.
Thank you.
Okay.
Thank you, Chair.
Good. Yes, Senator Decor.
Could you stay?
Yes.
With the way that the blood alcohol level is where it's at now, how would somebody, because it's deeper than just, this amount of alcohol level is equal to 1 can of beer, or I think it's a little more complex, to quantify somebody's blood alcohol level based on their height, their size, those kinds of things. And so my question is a first-time offender not really understanding what the chemical quantification is, how would they be able to know in advance what is triggering or going over the amount of that level?
So for the thresholds of blood and breath alcohol, so that element of being over that limit, our case law holds that for that specific element, it's strict liability. So it's the mere fact that you are over would be sufficient to establish that element. That doesn't remove the state of mind requirements for other things like were you driving, were you consuming alcohol. But part of the reason why we have this uniform requirement is because alcohol does affect people manifestly in different ways, right? So if you look at the standardized field sobriety tests, we've seen cases where people, maybe because they've been pulled over so many times, they actually do not too bad on the field sobriety test. Then we do the blood draw and it's like, this person is way over the limit. The big problem with alcohol, of course, is that many people, it impairs their perception of their own impairment, right? And so we have tests where people assume that they're driving fine. But when you measure, you put them on a video remotes, you're seeing all sorts of indications of impairment. And just one of those small misjudgments when you are operating, a massive piece of equipment that's moving at 60 miles an hour with pedestrians, with other motorists, with children, that can lead to some very deadly consequences.
Do you have any idea, maybe roughly, about how many first-time offenders there are?
I don't have that statistic. I will note that oftentimes people are prosecuted as first-time offenders, even though they've been arrested many times for DUIs.
Okay, and then my very last question, we can move on. Thank you, Chair. Thank you, Committee. Do you believe that imposing this will overwhelm the system?
Well, I mean, that is a legitimate concern. In State versus Lee, that was one of the cases that looked at the backlog that occurred when these offenses were prosecuted as misdemeanors, and then defense attorneys just demanded jury trials. So yes, unfortunately, a lot of people commit this crime, and that means that for it to be prosecuted and adjudicated, it's going to require significant court resources. So it's a balance. That's part of the reason why the first offense is a petty misdemeanor, even though the consequences of drunk driving are so serious.
Okay, thank you so much, Daniel. Thank you very much. Thank you, Chair.
Thank you. Okay, anyone else wishes to speak to SB 2329? Let's move on to SB 2399, and this is relating to the GE tax exemption for aircraft maintenance, and it provides a GE exemption for the sale of material parts or tools used for aircraft service and maintenance, or for the construction of an aircraft service and maintenance facility. DOT, did you have any comments on this one? Okay, DOT, taxation. All right, okay.
Good afternoon.
Good afternoon.
Committee members, my name is Garrison Kirk, Department of Taxation. We'll stand on our written testimony, just providing comments on administration, and I'm here for any questions.
Okay, thank you so much. Thank you for bearing with us today as well. Alaska Airlines and Hawaiian Airlines, Jacob Aki, aloha.
Thank you, Chair, Vice Chair, members. Jacob Aki on behalf of Alaska Hawaiian Airlines. We stand on our written testimony, but just wanted to provide a few key highlights. This bill is meant to address a loophole that the recent court ruling has unfolded, which would subject locally purchased parts to the GET tax while also exempting the identical parts purchased out of state and brought into the state. So what this bill does is it also responds to the court's invitation for the legislature to reaffirm the legislative intent of this measure or of this particular piece of statute, which was implemented in the 1990s to align the GET of the parts with the use tax framework. I think this bill also helps to ensure that the state remains competitive with other states that have similar exemptions to not only attract, but to also retain maintenance facilities here. As many of you know, aircraft maintenance is a really good job. It's a really high-paying job, and we employ many local maintenance folks to ensure not just the maintenance of our plane, but also the safety of our guests. So we will stand on our testimony, and we are available for any questions that you folks might have. Thank you.
Okay, going back, Jacob, comments with regards to, other states, I think we're the only state that has GE tax structure as well. And so in some sense, on the mainland as well, the work is pretty much reasonably done. The impacts to the airline industry. And this is rather interesting because, we also talk about trade unions and having people work in the industry, and maintenance is a highly respected industry, and we need workers as well. But it's something that we should consider as well, because we need you folks. And there's costs that extend up to all of us, the passengers as well, in picking up the tab.
So, this is something that, Hawaiian had originally operated under the understanding that we were exempt, and I think under recent times, and particularly, I think, as this was being pursued in the courts, was something that we have continued to.
Did you say there was a suit that happened?
Yeah, so the Intermediate Court of Appeals recently ruled in November of last year.
They ruled, but who filed?
I think it was
Who filed the
Hawaiian.
Okay. Joining.
Pre-combination, yes, so, yeah.
Okay. And that was for the relief of the GE at that time?
It was in protest of.
Okay.
Correct.
All right, protest
Of payment.
of the use of the GE. But
Yeah,
it should
recognizing
include-
that previously Hawaiian had been operating, under, Hawaiian had not been paying the GET on it because we were under the interpretation that we were exempt. So what this does is what it does is it clarifies. Yeah.
Okay, interesting, but Hawaiian thought that they were exempt
And this,
initially,
yeah,
but
and it was
wasn't in
something,
statute?
yeah, and it wasn't something that was challenged until I think DOTAX
Okay,
in
so
recent
just
years.
to refresh our memory again, you're saying the courts ruled already,
The Intermediate Court of Appeals ruled
and the
in
ruling was?
that Hawaiian is subject to the GET of the
Okay,
parts.
so hence this
Correct.
bill.
And I think our testimony also mentions that that part of the reason why this bill is so needed is it aligns with the original legislative intent of this particular piece of statute.
And well, it's kind of unfortunate though that the courts made a decision this late because, we were there when Hawaiian did the improvements to the aircraft part, the facility, and that was a big job,
Yeah.
building two huge facility for maintenance. But then, at that time, they weren't exempted, right?
Correct.
They were paying a huge amount, including the new Mauka concourse.
Yeah. Yeah, I think our main concern is making sure that we can close this loophole because what this essentially says now is that we can just purchase the parts on the continent, import it, and we can avoid paying the tax. We want to make sure that we're able to, operate fully within the state, and to keep these jobs here, and to have these parts locally purchased. So,
Okay.
yeah.
All right. Now, so when you purchase, you're doing your own aircraft,
So we purchased the parts from Boeing.
okay, so
Yeah.
that's on your individual airlines
Yeah.
doing the maintenance and
Yeah.
such.
We
You-
purchased the parts from Boeing, but we do the actual work. So I think,
Yeah,
and I would have to go back to the court's ruling, but, in essence, if we purchase the parts from Boeing, but somebody else did the work, then they would be exempt. But because we do the work here in state, we are not exempt.
Okay, DOT, Ed, like we're gonna be doing improvements to Diamond Head side on Terminal 3. So when you do, but we hire contractors to build and maintain, and they gotta change, the parts or whatever. The contractor pays as well then?
Yes.
Yeah,
But they're not in this bill?
Yeah, and this is more so focusing explicitly on aircraft maintenance parts, so not necessarily,
Okay.
Yeah.
Oh, okay,
The
not
overall
buildings,
construction, no.
infrastructure and everything
no, yeah,
else.
this is looking at the
Okay.
aircraft maintenance.
Yeah, okay. Thanks. Senator Elefante.
I have a question for Mr. Aki. So with the ICA's ruling in November of last year, was there a backlog of payment that Alaska had to pay for anything, was like in that ruling?
So, and I would have to go back and look at exactly what it was, but to my understanding, we had paid, right, because Boeing would be subject to the GT, but what we had done is that we paid Boeing, but we were going to DOTAX for a refund of that.
I see.
And that's what spurred all of this, was that we were going to DOTAX for a refund, and because of the interpretation by them, they denied our refund of that GET, right? So we were still paying Boeing.
Got it.
Yeah.
Okay, thank you for the clarification.
But you never got the refund?
Correct.
Okay, all right.
Thank you.
Thank you. Interesting. Tom Yamachika, Tex Foundation of Hawaii on Zoom. Tom, you still around? Okay, he did have some comments of interest as well. Chamber of Commerce of Hawaii, Sherry Minor, or member, in support of Kohala Coast Resort Association, Stephanie Donahoe, in support, Megan Blazak, individual in support. Is there anyone else wishes to speak to SB 2399? Okay, yes, Senator, The court.
It's a long day.
No.
It's a long day. I don't take it personal.
No, but
don't
we
act-
do have some, we have the court and the coit.
Coit, that's
Yes,
true.
so I have to make sure that it's best not to say yet. Okay, the court, yes.
Don't tax, please. And I didn't find this in your testimony, but will this exemption result in any kind of revenue loss for the state?
Well, there has to be, I would think, but how you determine it, I would have to go back and check. Because obviously there's a starting point with this exemption is already in place for the facilities. So you know that, but how do you determine, or how do we know or determine what parts? Or they purchased, I mean, we just don't have that information, I believe, so.
Okay.
But, you
I
know,
figured because you didn't have it in your testimony, you might not have
yeah,
it.
and I don't, like I said, I don't know if they'd be able to come up with anything other than a wild guesstimate. Maybe, I can go back and ask.
Okay, okay, thank you very much.
You're welcome.
Thank you. Jacob, would you happen to know, or maybe a guesstimate on how much revenue it could cost the state? I know it's a hard question, sorry.
Yeah, we do have numbers, but because of the competitiveness of the industry, publicly sharing that data on, in front of the committee wouldn't be in our best interest, but would be willing to talk to you folks offline to share, I think, what our estimates are. Thanks.
Thank you, thank you, thank you, Chair.
Okay, no tax. So this would be something new. I'm not sure I think we need to look at the statute, I think, and see what the effectiveness of this in order to give you guys time to work out the mechanism in the office. Let's see, let's look at the bill.
Yeah, and I believe the bill was set for July 1st, 2026.
Okay,
And
so
we had
then,
recommended just
yeah.
moving it to January 1st of 2027, so we can.
Okay, what's current?
They had July 1st.
Okay, July 1st, oh, that's right after session. That's on approval. Staff, just to add, make a note on the recommendations, see if I've moved up the date earlier. Probably to, let's see, July 1st. So, January 1st, 2027 gives you guys time, 6 months. Okay, all right, thanks.
Thank you.
All right, let's move on. SB 2429 relating to traffic safety, and this establishes the framework for the use of intelligent speed assistance technology for habitual speeders and requires a report to the legislature. And I think this is part of the discussion with regards to speeding, I guess. Is this the one? DOT.
Chair, duty is in strong support.
Okay, okay, Alliance for Automobile Improvement, Innovation. Tiffany?
Aloha Chair, Vice Chair, members of the committee. Tiffany Yajima on behalf of the Alliance for Automotive Innovation. The auto manufacturers support the intent of this measure. We do ask for some proposed amendments that we've put in our testimony that speaks to automotive responsibility. Thank you.
Okay, thank you so much. Thanks for bearing with us today. Okay, Mothers Against Drunk Driving, the MAD Group, Archie Cole has been so active with Committee on Transportation comments and recommendations in support this time as well. Okay, testifying for Smart Start in support. Deborah Kofi, and I know some came earlier, so they continue to send communication in support. Chad Taniguchi.
Thank you, Chad Taniguchi. So when drivers habitually get speeding tickets, or when they one time go really fast, that means they don't care, or yeah, they don't care. And so this allows the judge to say that we're going to put a speed limiter on your accelerator. So even if you don't care, you still can't go over a certain speed, over the speed limit. And unfortunately, that's your behavior. That's told us that you don't care and you're a danger to the rest of us. So thank the chair and the members of the committee for supporting ignition interlock, which functions similarly, red light cameras, speed cameras, and this is another technological innovation that will control the human being who can't control themselves so that we can have safer roads and nobody dying on our roads. Thank you.
Okay, well, your industry, your bicyclist too, has, you're on the road a lot.
Yeah.
So it's of interest that you have safety measures all the time.
Yeah,
Okay.
for everybody. Thank
Yeah.
you.
Thank you so much. Ampo, sent communication in support. Anyone else wishes to speak to SB 2429? Okay, hearing none, let's proceed to, oh, yes. Okay, who do you want? Ed? Okay.
Guilty. Sorry, in reading the bill, I understand that this cost will be imposed to the driver. Any idea what price ranges we're talking about?
I think it's equivalent to the ignition interlock, but I can get you the numbers though. I'll get the committee the numbers for all this.
Perfect, thank you so much. Thank
Okay.
you. Thank you, Chair.
Yes, thank you. Let's proceed then with SB, I think it's 2463, relating to the use of intoxicants while operating a vehicle. DOT.
DOT's in strong support.
Okay. Let's see. Okay, Office of the Governor. Okay. Will Kane sends communication in support. Public Defender, Haley.
Good afternoon again. Haley Chang, First Deputy at the Office of the Public Defender. We have submitted a testimony in opposition to this bill, and I just want to highlight a couple of the main reasons why. First and foremost, our existing statute already allows law enforcement as well as any prosecuting agency to prosecute individuals for unsafe driving related to being under the influence of an intoxicant, even in the absence of a blood or breath alcohol measurement. That's under A1, subsection A1 of 291 E61. Therefore, you do not need a BAC of any amount to prosecute someone who is under the influence and who is driving unsafely. So we do not believe a reduction of the existing BAC is necessary. Additionally, although we of course support safe driving and understand the need to have people be maybe more educated and explore different options, it is not illegal to consume an alcoholic beverage and get into your vehicle as long as you do so safely and responsibly. One of the things that I'd like to highlight to the committee is that under the existing law, before the proposed changes, a BAC of 0.05 meant there was a presumption that you were not intoxicated. Because again, there's a recognition that you can have a measurement of some alcohol in your system, but not be under the influence for driving purposes. What this new measure is proposing to do is to reduce what was previously the presumption of non-intoxication to now you can be prosecuted and charged with a DUI offense. So we also have cited other concerns related to congestion, diversion of resources, things of that nature in our testimony. Thank you for the opportunity to comment.
Thanks, Haley.
Thank you.
Thank you very much. I did call you, yeah? Ed, all right, okay. Since I see those on Zoom, let's do the Zoom people first. Let's see, Keldon, County of Hawaii. Keldon Waljan, you're on.
Aloha, Chair Inouye, Vice Chair Elefante, Senator DeCourt, and Senator Lee, Hawaii County Prosecuting Attorney Keldon Waljan. We stand in strong support of this bill. This bill is about saving lives. Alcohol-related traffic fatalities continues to be a significant concern across our state. Lowering BAC to 0.05, it's not uncommon. It's common across the globe. It's the international norm. The U.S. is actually late to the table. Contrary to what the opposition believes, lowering the BAC will not result in significant increases in arrests or burdens on police resources. Lowering the BAC is a simple and it's an effective way to prevent alcohol-related deaths. This bill will serve as a general deterrent. This is different from the bill that we talked about earlier. It's a general deterrent bill. It's going to address those who drink excessively and choose to drive. It will encourage people to think twice before they get behind the wheel, get a designated driver, use rideshare, be responsible. Let's all do our part. 0.05 will save lives. Mahalo for the opportunity to testify today and submit on our written input. I'm available for any questions.
Thank you, Kelvin. Maui prosecuting, let's see, attorney's office in support. Let's go to the next Zoom. Rick Collins, is that you, Rick?
Yes, thank you, Chair, Vice Chair, members of the committee. My name is Rick Collins. I'm with the Hawai'i Alcohol Policy Alliance, which is a program of the Hawaii Public Health Institute. We are in strong support of this bill for many of the reasons that Keldon mentioned. It's backed by science. It's one of the most effective pieces of legislation we know of to reduce alcohol-impaired driving, crashes, fatalities on our roadway. In 2023, 42% of all of our traffic fatalities involved an alcohol-impaired driver, compared to the national average of 30%. I also want to point out, and the SR 151 working group that created a report that thank you to Senator Lee for authoring that Senate resolution, pointed out a couple of things that I just want to note as well. There was a meta-analysis done on 0.05 around the globe, and what they found from that research was, on average, there's an 11.1% decline in fatal alcohol crashes as a result of moving to 0.05. I also want to just point out that the report noted that a 0.05 law is fiscally responsible as well, because it reduces the strain on hospitals, families, and taxpayers. Utah's 0.05 BAC law showed a 10.8% decrease in the number of crash injuries during the first 12 months the law was in effect. If a 10.8% increase in Hawaii crashes were to occur, that would be 56 fewer crashes. The average cost is $275,000 per crash. So you're talking about saving tens of millions of dollars here in the state. I also just want to point out that one more piece is that Utah's showing promising effects. They are at currently, over the last 4 years, I believe, only an average of 16% DUI fatalities, and we're at 31%, so nearly double that. And they're like us in many ways in terms of being a tourism-driven industry, a state as well. Thank you for the opportunity to testify, and I'm here for any questions.
Thank you, Rick. And just to confirm, Rick is with the Hawaii Public Health Institute. McKenna Young with MAD. Aloha. You're on, McKenna.
Aloha, Chair, Vice Chair, members of the committee. My name is McKenna Young. I am the Program Director with Mothers Against Drunk Driving, and I am here today in strong support of SB 2463. The reason to support this bill is simple. It will save lives. I also want us to think back as we've been here before. When the legal BAC was lowered from 0.1 to 0.08, there was significant pushback at that time as well. Concerns about enforcement, personal freedom, economic impact, but the results were clear. That change led to a 10.4% reduction in alcohol-related traffic fatalities with no change in alcohol consumption. SB 2463 is the next evidence-based step forward. Research shows that impairment begins well below 0.08. At 0.05, drivers experience reduced coordination, slower reaction times, and impaired judgment. Adopting a 0.05 BAC limit is estimated to reduce fatal alcohol-related crashes by 11%, saving at least 1,700 lives every year. And Utah's experience reinforces this. Since implementing a 0.05 law in 2018, more than 1 in 5 drinkers changed their behavior, choosing to plan ahead for a safe ride home. There was no decrease in alcohol sales and no increase in DUI arrests. This policy does not punish responsible behavior. It simply encourages it. This issue is especially urgent for Hawaii, as in 2025, our state experienced a 20% increase in traffic fatalities compared to 2024, and alcohol-related fatal crashes here have historically been higher than the national average. I also just want to address a common misconception Lowering the BAC does not change how law enforcement operates. Drivers are stopped for an unsafe behavior, swerving, speeding, running red lights, not because of a number. Finally, this bill is about people. It is about victims whose lives were forever changed, families who carry unimaginable loss, and tragedies that were entirely preventable. I respectfully urge you to pass SB 2463. Mahalo for your time and consideration.
McKenna, I have a question for you. You've been, and those before you have been very active since I've been here in the many years, and it seems like this bill always comes up. How many times we've had this bill before us?
I believe this is the 4th or 5th year now.
Okay. Right. Okay, thanks for all you do.
Thank you.
Let's see. Pamela Tumpak?
Yes,
How are you,
thank you.
Pamela?
Aloha. I'm Pamela Timpot, president of the Maui Chamber of Commerce, and really appreciate being here with you today. Mahalo, Chair Inouye, Vice Chair Elefante, and members of the committee. The Maui Chamber of Commerce is deeply concerned about the proposed lowering of the blood alcohol content threshold for driving while under the influence of an intoxicant. This bill directly impacts local residents, bars, breweries, wineries, and distilleries, and by extension, thousands of jobs small businesses rely on, as well as responsible, moderate alcohol consumption as part of Hawaii's tourism industry and community life. We hear the concerns from MAD, but we just want to look at the research, and I think we have difference of opinions on some of the research. Research and experience from other states suggests that the vast majority of the fatal alcohol-related crashes involve drivers with BAC levels well above the current legal threshold, often those with significant impairment or prior offenses. Lowering the threshold to 0.05 risks criminalizing moderate legal behaviors, such as having a single drink with dinner, without clear evidence that it will meaningfully reduce serious accidents. Utah remains the only state with a similar law, and the outcomes there, in our opinion, have been inconclusive, particularly given broader trends in declining DUI fatalities and the unique circumstances of recent years. Further, other states who do have a 0.05 BAC only use that threshold for repeat offenders. And you have another bill before you that gives different levels of addressing, these offenses and having people be more responsible, dictated by levels of punishment that is, can be made available in a different bill. The proposed change here, though. Yes.
Pamela, I think your time is up. Our clock was too late, so.
Oh, I see. Okay.
We gave you a little more time.
Bless
but
you.
thanks for your comments
Thank
as
you.
well. Okay, there should be Doug Martin on Zoom.
Yes, I'm here.
Proceed.
Okay. Hello, Chair, Vice Chair, and Committee. My name is Douglas Martin, and I'm a student in the Bachelor of Social Work program at UH Manoa, and I'm here to give my testimony in favor of the bill SB 2463. The amendment will lower the measurable amount of alcohol from the maximum of 0.08 to a maximum of 0.05 on blood samples and breathalyzers. As a social work student, a future substance abuse counselor, and also as a former, I was an alcoholic for 13 years, and I'm 13 years sober now. I believe this is a strong amendment to help prevent drunk driving. This bill can help others avoid making mistakes that I did, and help others make mistakes that I know they will regret, because I did a bunch that I regret. And one of them was drunk driving. And if the alcohol limit was lowered, I feel, me personally, I would have thought twice about having that extra drink. So personally, I vote in favor of this bill so it can help those who may not know they have a problem, much like I did, and help others. Thank you so much.
Thank you, Douglas, sorry. We're on a tight schedule here, and we got one more bill to go. Now, there are some of you here who wanted to testify on this measure. You want to come up now? Okay, public defender, prosecutors, yes.
Good afternoon, Chair, Vice Chair, and members of the committee. Our department did not submit written testimony for this specific hearing, but on other bills, we have consistently supported it. I just wanted to highlight again the deterrent effect of this bill, as well as research that indicates that impairment begins around the 0.05 threshold. And again, anyone who drives and follows every traffic law in Hawaii, it's legal to avoid an intoxication roadblock. Someone who follows every single traffic law is not going to be prosecuted under this because the police won't have reasonable suspicion to stop them.
All right, thank you so much. Okay, yes. And state your name for the record as well.
Aloha, Chair, committee members. My name is Brittany Cass, and I'm sitting before you because I survived something that I should have never have happened. I am here as a statistic. I am here as a mother, wife, military spouse, and a survivor of a violent, preventable drunk driving crash that changed my life forever. And I want to be clear about that one thing from the start. If the laws had been stronger, I might not be here at all because this wouldn't have happened in the first place. According to NHTSA, about 37 people in the United States die every single year by drunk driving. That's one every 39 minutes. While sitting here, another family is being shattered. Another phone call is being made. Another life is being erased. In 2022 alone, 13,524 people were killed in an alcohol-impaired driving accident. Every one of those deaths was preventable, not accidents, not tragedies, but could have been prevented. I know this because I'm living proof of what happens when prevention comes too late. And here's a picture of me 2 days after my crash. On the day that changed my life, someone made a choice. That choice to drink, the choice to get behind the wheel, and the choice to collide with my family and our future forever. In an instant, everything that I was and everything that I would be was ripped away. I survived, but survival is not the same as living. I live with the pain, the trauma, and the fear that never fully leaves. I live with the knowledge that my children were almost left without a mother, and my husband almost became a widower. That our story almost ended because the law told someone that they are okay enough to drive. This is why we're here today with SB 2463, and that is why 0.8 is not enough. Sorry. Science tells us that lawmakers must not ignore drivers are significantly impaired at 0.05% BAC. Reaction time slow, judgment fails, vision narrows, coordination drops. At 0.05 to 0.079, research shows that your risk of being killed in a single vehicle crash is at least 7 times higher if you hadn't been drinking at all. 7 times. We would never expect a product to fail 7 times and continue it. Yet we continue to allow people to drive the way we call it legal. Lowering the BAC to 0.05 is not about punishment, it's about prevention. Mahalo for your support and for hearing about my story.
Can you, just for those, can you show your picture there to the staff and then in the back there so Zoom can pick it up as well on both sides and the left? Okay, thank you so much. Thanks for your thanks for being here as well, and good luck to you. Okay, anybody else? Yes.
Garrett Marrero, Maui Brewing Company, Hawaiian Craft Brewers Guild. With respect to Brittany, it's a horrible thing that her and her family and anybody who's experienced an accident due to alcohol impairment, my heart goes out to you. I want to be very clear, this isn't about money. People don't buy the products that I make and make in large scale the same choices. When you talk about cheap mass-produced alcohol in 30 packs that people consume on the side of the road, unfortunately at times, and we're in a different world. I'm here because of the...
Yeah, state your position.
Sorry.
In support.
So I'm in opposition to the bill.
All right, continue.
I'm in very strong support of stronger penalties, as mentioned earlier. It's a very difficult thing to testify on this, and the only reason I chose to this year was because we are facing an economic crisis in Hawaii. Job creation is gone. We don't have enough employees. I see tourism continually to decline. I see the food and beverage industry continuing to decline. And I believe that this puts us as an outlier further into a negative impact on tourism. I want to be very clear that we're adamantly opposed to any sort of irresponsible alcohol consumption, and we would support any measure if we could eliminate drunk drivers from the earth. That would be a wand that any one of us would choose to do. My question is around the data, and the gentleman earlier, Rich, said that no arrests have gone up. I pulled data last night from NHTSA, IHAS, a bunch of different institutes, and in 2018, there were 8,500 DUI arrests in Utah after 2019 when the BAC law was lowered. There were 11,000 last year with an average blood alcohol content of 0.14, which is nearly 3 times their legal limit. Utah did also set recently a record for alcohol fatalities of 69 versus 48 in 2018, 29 in 2019, and it's consistently gone up every year since then. So my concern is really around the data. It's not around this bill in certainty. But again, we're in opposition to this because we feel it negatively impacts tourism, jobs, and the economy, but we would support anything that makes it safer for our people. Thank you.
Any questions? Okay, let's move on then. Anyone else, did I miss, want to speak on to SB 2463? Moving on to the last item. Yes. Oh, Chad.
Sorry,
Okay.
Chair.
Okay.
Before smoking was common, everybody accepted. Now still drinking common, and many people accept. So eventually, we're going to get to 0.05 or maybe even 0.03. And
Your support or oppose?
support.
Okay.
Strong
All right.
support.
Thanks, Chad.
Okay.
Okay, we heard you. Thank you. Let's move on then to SB 2665, and this is relating to renewal of driver's licenses, and it requires the applicants for driver's license renewal who have received a traffic citation or infraction within the previous 5 years to complete an educational course that includes a road safety video developed by DOT and a written road safety examination. Let's see. And just for the record, on SB 2463, we had 28 in support, opposition 7, and comments 2. Office of Public Defender on SB 2665.
Good afternoon again. Haley Chang on behalf of the Office of the Public Defender. We have submitted testimony in opposition to this measure and really want to highlight a couple of very significant things. Anybody who is intimately familiar with the criminal system, especially as it's related to traffic offenses, especially driving without license offenses, knows that we're already in a crisis situation trying to get people validly licensed, remove stoppers from their license, being able to renew their license. This measure, which has no qualifications on the types of citations or the types of infractions, as written, if you got a parking ticket, that's a citation. You would have to take a course. And I think we've outlined our concerns related to that in our written testimony. But I do just want to convey that this, in our opinion, will not deter people from bad driving if that's the intent of the measure. An alternative proposal would be to attach the requirement of a driver improvement class or course or video or workshop to certain criminal traffic offenses such as reckless driving, inattention to driving, that already exists as a mandatory provision for excessive speeding, rather than putting this burden on all of the drivers of the state who may have as little as a parking ticket or other non-dangerous moving violations. So we'll submit additional arguments on our written testimony. I'm available for questions. Thank you.
Thank you so much. DOT?
Thank you, Chair. It's with the Department of Transportation in strong support. Agree that we should be attaching the types of citations to the types of violations or the types of courses everybody should go through. I disagree that this would not be successful in deterring people from bad behavior. Right now, we're in a society where people, when we start looking at fines, fine structures don't matter anymore. And we're in a society where people are buying $12 shakes from McDonald's so somebody else can pick it up for them. So they have the ability to just stay home and get it. So really money is not the thing anymore, but time is. If I told somebody you're gonna spend the next Saturday or the next 2 Saturdays in a 6-hour training, if you speed in the system, I'm pretty sure we'll have less people speeding. So I would love to be able to start talking about how we can tie more of these to the types of offenses to ensure that it's appropriate, but we strongly support. Thank you.
Okay, thank you so much. Okay, City and County of Honolulu, Department of Customer Services sends comments. Let's see. Did you have comments on this one? No, not this bill. All right. Customer Service, City and County of Honolulu, and Susan Davis, comments as well. Larry Viray in support. Daniel Smith in support. Charmaine Duran in support. Is there anyone else wishes to speak to SB 2665? In other words, then we will say aloha to the measures before the Committee on Transportation, and we'll go into decision-making. I think we'll make the clock time, so. Yes, okay. So the Committee on Transportation will go into recess. Okay, the Committee on Transportation is going into decision-making on the amended hearing notice of February 3rd, Tuesday at 3 p.m. And we'll start with SB 2008, and this is relating to statewide traffic code. And this is the chair's 60-mile-per-hour bill. And members, I think there were enough discussions on this. I will be deferring this measure. Okay. SB 2009, relating to motor vehicles. Chair's recommendation is to, there's a technical, not substantive amendment needs to be made on this measure. And I'd like to amend further that we have the language, I believe, that's recommended by, I think this one here is.
It's recommended to include a centralized
Okay,
system.
who made this one? Oh, okay. Do we have the bill number? His bill. Oh, this one here. Okay, all right, good. Members, with regards to SB 2009, there's a measure that's SB 2498, and the recommendation on this SB 2498, the chair would like to add that language into this measure as well. And I'd like to read this part with regards to adding this language into section 2 of 2498 as amended. And that has to do with the section I, upon receipt of the official form, the Director of Finance shall immediately notify all applicable state and local agencies of the transfer through a centralized notification system. If you agree to that measure, there's for section 2 on J as well, adding upon receipt of the official form, the Director of Finance shall immediately notify all applicable state and local agencies of the transfer through the centralized notification system. And my understanding is presently, when there is a change, it could only be, and I think the process right now only goes to one system and not applicable to all the others as well. And so I think what we're saying is when the Director of Finance, and everything should notify all of the other agencies so everybody has the same information the same day. And it's because of some of the issues that has arisen is that it could happen on a check on something that the next day or a couple of days later, another island or another agency won't have the information. And so if the recommendation would be the notification portion. And as well, on section 3, no later than July 1st, 2027, each county director of finance shall establish this centralized notification system that's automatically and instantly updates all the applicable agencies. And that's what I think we want to make sure that everybody's on the same page the same day. Okay, that it also includes all of including the law enforcement agencies as well, and DAGs and judiciary. Okay. So with that said, Chair's recommendation is to pass SB 2009 with amendments and the non-substantive amendment as well. Okay, Chair's recommendation for this measure. Vice Chair for the vote, Chair goes aye.
Chair's recommendation is to pass Senate Bill 2009 with amendments. Chair Inouye.
Aye.
Vice Chair votes aye. Senator Kanuha is excused. Senator Lee.
Aye.
Senator DeCourt.
Aye.
Madam Chair, recommendation is adopted.
Okay, thank you. SB 2026 relating to traffic safety. Chair's recommendation is to pass with amendments. And 1 second, I think previous measure, SB 2009, because there's a lag of time, the recommendation is not to pass with upon approval, but to move the date to July 1st, 2027, I believe. It's in there. Okay, thank you. All right. The SB 2026, Chair's recommendation is to pass with the amendments, and that included the comments from the Attorney General's office as recognized as well. And I believe AMPO had a support with comments as well. And the Chair would like to add a portion that would go to section 291 C27 on the emergency vehicle stop for emergencies, and on number 1, slow to a speed not to exceed. This one, maybe your comment, Director. AMPO recommends that one section, slow to a speed not to exceed 20 miles per hour below the maximum speed limit on roadways, with a speed limit greater than or equal to 30 miles per hour, or B, 5 miles per hour when the posted speed limit is less than 30 miles per hour. That's the only one that I'm a little confused. So.
They're recommending that,
Yeah.
recommending
On
specific
that
speed
particular one
limits.
from AMPO.
Yeah, I think all they're doing is just trying to say, proceed slowly and safely,
Okay.
right?
Okay, yeah,
I think for, in establishing the speed limit like that, they're trying to make sure that it's enforceable. And
Okay.
I think the
Okay.
prosecutor's office can indicate, but it establishes a speed.
okay.
And it's something
All
that I
right.
could
So
support.
it's okay?
Yeah.
All right, so we'll continue to then support AMPO's recommendation. All right, so with regards to SB 2026, Chair's recommendation is to pass with amendments. Vice Chair for the vote, Chair goes aye.
Okay, Chair's recommendation is to pass SB 2026 with amendments of the 4 members present. Any no votes, any votes or reservations? Hearing none, Madam Chair, your recommendation is adopted.
Okay. SB 2053 relating to transportation. Chair's recommendation is to pass with the non-substantive amendments and technicals and the amendments that was introduced by COPART and the amendments on page 6, line 1, replace the term insurer with insurance company to align with terminology used throughout the chapter. And on G, notwithstanding any other law to the contrary, supporting documents used to transfer ownership of a motor vehicle to an insurer, insurance company after payment of the damages for the result of total loss insurance settlement pursuant to this section. And on page 6, line 7, insert the words application for, that's before duplicate title, to more precisely describe the relevant document. And for the purposes of the subsection, supporting documents includes, but is not limited to, the power of attorney, application for duplicate title, and odometer disclosure forms. So SB 2053 to pass with amendments. Vice Chair for the vote, Chair goes aye.
Chair's recommendation is to pass SB 2053 with amendments of the 4 members present. Any no votes? Any votes or reservations? Hearing none, Madam Chair, recommendation is adopted.
Thank you. SB 2172, Chair's recommendation is to pass this measure relating to vehicles, and this was the terrain, the all-terrain vehicles and driving in the evening. Ed, you did have some comments that the department believes additional evaluation, safety analysis, and coordination with the enforcement and safety partners would be necessary before considering expansion of the ATV and UTV use on public streets. So this measure and the Department of Attorney General recommends the amendments. I'm not sure if you remember. Can I read the question, the AG's one?
Please.
Okay, they do say that they recommend the following because initially their recommendation were just to add the amendments. It has to do with the section 286-12. It's amended to read that all-terrain vehicles and utility terrain vehicles used as farm equipment shall be regulated as farm equipment and not as motor vehicles. And she underlines and added, except that all-terrain vehicles used as farm equipment shall be regulated as motor vehicles when operated on a street in accordance with subsection A to address the inconsistencies identified.
Agree.
You agree?
Yeah.
Okay, and then the second part of their recommendation is the addition of all-terrain vehicles to the definitions in certain sections of the measure as well, rather than as a whole to avoid ambiguity. Okay, now, interesting, goes on further. It is not clear whether the bill intends to expand the use of UTVs in the same manner as it does for ATVs, by allowing them to be driven during evening and night hours if they are equipped. But if that is the intent, then the UTVs should be included in the amendments to section 286-12, A and 6, and in the definitions in sections 431-110C-103 C.
Agree.
You agree?
Yeah.
Okay. Now, also, the Insurance Division of DCC A adds, rather than require, include the definition of utility terrain vehicle, a motor vehicle that accommodates one driver, one passenger sitting side by side, up to 6 people in the seat belts, include all-terrain vehicle in the definition of motor vehicle under the state's motor vehicle insurance law.
Yeah, makes sense.
Makes sense. Okay, we'll add that as well. And in section 2 of the bill, amend HRS 431-10C-103 by adding the definition of all-terrain vehicles, but I think we covered that as well, and they concur. All right, So Chair's recommendation on SB 2172 is to pass with amendments, recommendation from the Attorney General and DCCA. Vice Chair for the vote, Chair goes aye.
Okay, Chair's recommendation is to pass with amendments SB 2172 of the four members present. Any no votes? Any votes or reservations? Hearing none, Madam Chair, your recommendation is adopted.
Thank you. SB 2253 relating to highway safety. Chair's recommendation is to pass with technical, non-substantive amendments. We will take the prosecuting attorney Maui County clarifying amendments taken from Chapter 291E to avoid vagueness, issues regarding whether a person is under the influence of alcohol, drugs, as well as additional amendments to avoid merger and related issues as well. And the other attorneys in City and County of Honolulu and Hawaii County supports that measure as well. So with that said, SB 2253 pass with amendments. Vice Chair for the vote, Chair goes aye.
Chair's recommendation is to pass SB 2253 with amendments of the four members present. Any no votes? Any votes or reservations? Hearing none, Madam Chair, your recommendation is adopted.
Okay, SB 2355 relating to vehicle safety. This is the having the DOT adopt the rules with regards to the motor vehicle safety inspections. And we will pass this measure with amendments to include that DOT will continue on its part of the rulemaking, yeah, that they will concur as well. And amendments that applies to the regular passenger vehicles and not the commercial motor vehicles. Okay, so with that, SB 2355 relating to safety, vehicle safety, Chair's recommendation is to pass with amendments. Vice Chair for the vote, Chair goes aye.
Chair's recommendation is to pass SB 2355 with amendments of the four members present. Any no votes or reservations? Hearing none, Madam Chair, your recommendation is adopted.
Okay, SB 2332 relating to traffic safety, Chair's recommendation is to pass with the amendments. And there were Office of the Prosecuting from Hawaii County on an SD1, and the version of our communications were included in his amendments as well. And, oh, okay, all right, okay. To confirm, we are on SB 2392. We will also, okay, it's, I think that's pretty much, the City and County of Honolulu supports this measure as well, but no recommendations to amendments. Okay, so Chair's recommendation on SB 2392 is to pass with amendments. Vice Chair for the vote, Chair goes aye.
Okay, Chair's recommendation is to pass SB 2392 with amendments of the four members present. Any no votes?
No vote.
No vote for Senator DeCourt. Any other no votes? Any votes or reservations?
However, can I just make a really quick
Yes.
speech? I would like to just.
Senator DeCourt.
Thank you so much, Chair. I would like to say, although I don't believe any driving while drunk is tolerated at all, I do believe that the mandatory jail time of 10 days is pretty hefty. And I do believe that we can create more preventative measures with programs and opportunities while people are still trying to understand the blood alcohol level of their personal, that will personally relate to them. So although I strongly support the intent of the bill, with respect, I will be voting down. So thank you very much, Chair.
Thank you.
Okay, any other objections, reservations? Hearing none, Madam Chair, your recommendation is adopted of the four members present.
Okay, thank you. SB 2399 relating to the GE tax for the aircraft maintenance. Chair's recommendation that we pass with the amendments, and I'd like to add that we support the DOE tax on the effective date, and we'd like to amended to give some time. So January 1st, 2027 is to be the amendment. There is a recommendation from the Tax Foundation. If we want to move the bill forward, they would like to suggest that the definition for quote licensed aircraft carrier unquote be added. Jacob, any comments? No problem with that? Okay. And SMA recommendation, yeah, is to kind of look at the definition. Yeah, thank you so much. So SB 2399 is to pass with amendments. Vice Chair for the vote, Chair goes aye.
Chair's recommendation is to pass SB 2399 with amendments of the 4 members present. Any no votes or votes or reservation?
No vote for me.
No vote for Senator Decort. Madam Chair, recommendation is adopted.
Okay, thank you. SB 2429 relating to traffic safety. Chair's recommendation is to pass with amendments that also includes technical, non-substantive amendments. And we'd like to add the DOT recommendation requirement for the report on the effectiveness of the program will provide valuable data. Actually, it's just their support, no amendments. But Shanghai has sent amendments requesting language clarification in their measure, Section 286 Automobile Manufacturer Responsibility. And we'll add their recommendations that includes several of the measures. So Chair's recommendation to pass SB 2429 with amendments. Vice Chair for the vote, Chair goes aye.
Chair's recommendation is to pass SB 2429 with amendments of the 4 members present. Any no votes or votes or reservations? Hearing none, Madam Chair, recommendation is adopted.
Okay, thank you. SB 2463, Chair's recommendation. This is relating to the use of intoxicants while operating a vehicle. Chair's recommendation is to pass this measure with amendments that just indicate the technical, non-substantive amendments. Okay. Any discussions? Hearing none, Chair recommendation then SB 2463 pass with amendments. Vice Chair for the vote, Chair goes aye.
Chair's recommendation is to pass SB 2463 with amendments of the 4 members present. Any no votes or votes or reservations? Hearing none, Madam Chair, recommendation is adopted.
Okay. Thank you. SB 2665 relating to renewal of driver's licenses. Chair's recommendation is to pass with amendments that includes technical, non-substantive amendments, as well as the comments. Well, actually, it's just the date change, removing this date as well to July 1st, 2027 in amendments to Section 3. And Chair's recommendation is to pass SB 2065 is to pass with amendments. Vice Chair for the vote, Chair goes aye.
Chair's recommendation is to pass SB 2665 with amendments of the 4 members present. Any no votes or votes or reservation?
No vote for me.
No vote for Senator Decort. Madam Chair, recommendation is adopted.
Okay, thank you so much. And this concludes the Department of Transportation and the Committee on Transportation hearing notice of February 3rd. This concludes our Tuesday's agenda.